Welcome back to another explainer. So, if you've ever dreaded the idea of spending years and who knows how much money in a crowded courtroom, well, you're in exactly the right place. Today we're taking a fascinating chronological journey through the life cycle of a dispute, but entirely outside of that traditional system. We're going to be looking closely at Republic Act 876, also known as the Philippine Arbitration Law. We'll trace the whole process from the very first spark of a dispute all the way to the final binding award. Here's our roadmap for today. We're going to cover understanding Republic Act 876, starting the arbitration process, appointing the arbitrators, hearings and procedures, the final arbitration award, and finally, framing justice, two approaches.
All right, let's jump right into Section 1, Understanding Republic Act 8076.
So, at its core, the arbitration law is pretty straightforward. It allows two or more parties to agree, in writing, that's key, to submit a controversy to one or more arbitrators. This could be an existing issue or even something that might pop up in the future. Instead of filing a massive lawsuit and waiting years in the traditional court system, the parties essentially opt in to a private, structured resolution process. It's basically a mutual agreement to just bypass the standard litigation route entirely.
But, the law has some very strict boundaries about who and what can actually participate. Not everything can be arbitrated. For instance, infants or anyone judicially declared incompetent are completely disqualified from these agreements. And on top of that, certain specific cases, like labor controversies that fall under the Court of Industrial Relations, are explicitly excluded from this act. So the law definitely knows its lane, and it stays in it.
Moving on to Section 2, starting the arbitration process.
Okay, so how does this actually kick off? Well, the process officially starts with a demand. And no, you can't just send a casual email. The demand for arbitration has to be served by registered mail or personal service, and it needs to clearly state the nature of the controversy and exactly what relief is being sought. Once that's done, the clock starts ticking. The party making the demand has to name their appointed arbitrator within 15 days. Then, the other party, the one receiving the demand, has a very strict 10-day window to answer. It is a rapid, highly structured opening act. Now, what happens if someone signed an arbitration agreement, but they get impatient and file a traditional civil lawsuit anyway? Well, the law actually anticipates this. If a suit is brought to court, the other party can file a motion to stay the civil action. And the court doesn't drag its feet here. It has a rigid 10-day deadline from the moment the motion is heard to make a decision. The goal? Freeze the lawsuit and force the parties back into their agreed-upon arbitration.
All right, Section 3, appointing the arbitrators.
Think about it. You are handing someone the power to essentially decide your fate, so naturally their qualifications are heavily regulated. An arbitrator has to be of legal age, fully enjoy their civil rights, and obviously know how to read and write. But to ensure absolute impartiality, there are stricter rules. They cannot be related by blood or marriage within the 6th degree to either party. Plus, they can have zero financial or fiduciary interest in the outcome, and absolutely no personal bias that might mess with a fair award.
But, human nature being what it is, we really have to ask a tough question here. What happens if, after an arbitrator is appointed, someone discovers a hidden conflict of interest or a clear bias?
The law addresses this head-on. If an arbitrator discovers any circumstance that might even create a presumption of bias, they are legally required to immediately disclose this information to the parties in writing. Once that's out in the open, the parties have a choice. They can either mutually agree in writing to waive the issue and just proceed, or they can declare the office vacant and appoint someone entirely new. Basically, transparency is non-negotiable.
Section 4, Hearings and Procedures.
So, once we're actually in the hearing, an arbitrator functions a whole lot like a traditional judge. Before hearing any testimony, they have to take a formal oath to hear things fairly. They're actually granted the power to issue subpoenas, meaning they can force witnesses to appear or demand documents. They administer oaths to witnesses, they can issue orders to physically safeguard whatever property is being disputed, and they can even conduct ocular inspections. That just means they can physically go and look at the premises involved as long as all parties are given notice beforehand. After all the oral arguments are made and the witnesses have spoken, the hearings conclude. But the work isn't quite done yet. The parties have a very definitive time limit. Any final written arguments or briefs must be filed within exactly 15 days after the close of those oral hearings.
Moving to Section 5, the final arbitration award.
Following the close of hearings, the arbitrators don't just have forever to make up their minds. Unless the parties agreed to something else, a written award must be rendered within 30 days. And once that award is handed down, a party has up to 1 month to apply to the appropriate court for an order confirming the award. That step is crucial because it gives the decision the enforceable weight of a real court judgment.
Now, sometimes things go wrong. A court can completely throw out or vacate an arbitration award. But I have to stress, it is incredibly difficult to do so. You have to prove very specific, extreme circumstances. We're talking about proving the award was procured by outright fraud, corruption, or undue means, or proving evident partiality in the arbitrators, or showing the arbitrators acted badly, like blatantly refusing to hear perfectly relevant evidence or postponing without cause. A court can also vacate it if the arbitrators completely exceeded the powers granted to them in the very first agreement.
And here is a fascinating, almost comical detail written directly into Section 24 of the Republic Act. If a court does vacate an award, the costs awarded to the prevailing party cannot exceed 50 pesos. Yes, 50. That's barely enough for a cup of coffee today, but it is a highly specific cap cemented right into the law itself.
Now, as we said, vacating an award completely destroys it. But what if there's just, a typo? Well, the court also has the power to simply modify or correct an award. But again, the grounds are strict. It's for things like an evident miscalculation of figures, or deciding on a matter that wasn't actually submitted to them, or maybe a minor flaw in form that doesn't affect the actual substance of the case. It's really for fixing technicalities, not for changing the court judgment.
And finally, Section 6, Framing Justice, Two Approaches.
To truly understand why arbitration even exists as an alternative to the courts, we have to step back and ask a foundational question. How do we actually define justice in the aftermath of a dispute or harm? Well, traditional courts often lean heavily on retributive justice. That approach focuses on the past. It views offenses as acts against the state. It emphasizes an adversarial relationship, a clear winner and a loser, and it essentially asks what law was broken. Restorative justice, on the other hand, focuses on the future. It views harm as an act against victims and the community. It emphasizes dialogue and negotiations, and it asks what needs to be done to repair the harm. Arbitration, with its focus on mutual agreement and private resolution, often borrows a lot from the spirit of restorative justice.
We're going to leave you with a scenario pulled straight from the activities section of our source text. Imagine two parties are halfway through their arbitration hearings, and suddenly they talk it out and settle their dispute on their own. What happens then? According to the law, they can actually request the arbitrators to embody that settlement directly into an award, signed by the arbitrators themselves. It really shows that mutual agreement is the ultimate goal here. But it leaves us with a final question to ponder. If parties are capable of settling their own disputes halfway through a formal hearing, are we overcomplicating justice from the start, or is the looming threat of an arbitrator's ruling the only thing that actually forces us to the negotiating table? Thanks so much for joining me on this explainer, and keep questioning the process.